episode of Level Up Law. We are live today with myself, Susan Ingalls, and our managing attorney in our Rock Hill office, Jamie Bell. And of course, as always, producer Kenneth Elliott is in the background, making sure all the bells and whistles are working. And just as a reminder, Level Up Law comes on every Tuesday at noon, so we invite you to check it out. You can always register on our Facebook page or on the calendar at our website at sclegal.org. And also keep in mind that every episode is uploaded by producer Kenneth Elliott to our YouTube page on the Level Up Law playlist there. And so you can go back and see all of the over 80 episodes of Level Up Law on all kinds of different subjects about the areas of law that we practice in here at South Carolina Legal Services. So definitely check that out. But before we get started, as always, we do want you to remember that this is not legal advice. It's just general information for the public. So if you have an issue with this subject or any other subject that we might be able to help you on, you are encouraged to apply for our services. You should always seek a lawyer for any legal issues that you have. At the end of the presentation, we will have a final slide that shows you all the information about how to get in touch with us and apply for our services. So definitely stay tuned for that if you think you will have need for it. Now, we can answer questions today if time allows. So be sure, and if you have a question, just put it there in the question box and we'll do our best to answer it. But we can only answer really general questions, not anything about a specific case that you might have. So I think without further ado, we will go ahead and get started. We have a fun theme for today, and I do want to take a moment to thank our friend at the South Carolina Department on Aging, Kay Hightower, who is a terrific partner with us and was very helpful in putting this together. So shout out to her. She is the Senior Consultant for Outreach and Partnership Building at the Department on Aging. So we have enjoyed a great relationship with Kay in building our partnership with the department and others as well. So thanks to Kay Hightower for that. So let's get started with our fun theme of the day. The title of today's presentation is A Ring Ain't Nothing But a Band That Doesn't Play Music. So we're going to talk about how common law marriage has impacted women in South Carolina, and as an important bonus, some tips for senior women on getting your legal house in order. So let's get started. So you might wonder, what does the Godfather of Soul, James Brown, have to do with it? James Brown is sort of our theme today, and one of the reasons is there's a very famous case involving James Brown here in South Carolina. It had to do with family court and probate court and all manner of other things, and it's a little bit relevant to our topic today because his life and career involved a number of marriages, involved common law marriage, and it involved bigamy, which is being married to two people at the same time or more than two people at the same time. So that was a great idea, I thought, for a fun theme for today's presentation. So before we get into common law marriage, we did want to go through a little bit of the history on being a woman in South Carolina, because this is our final episode for Women's History Month. Today is our last Tuesday in the month of March, which is Women's History Month. And so one of James Brown's many hits, it's Man's World. That has definitely been the case when it comes to a woman in South Carolina historically. And let's just start with antebellum and colonial South Carolina. And here's just 6 kind of thoughts on that I think we should know as modern women, you know, where things started to get to where we are today, not just in the nation, but in South Carolina in particular. So we originally, back in the day, not a lot of legal rights for women, had to depend on the men. And I always, and I mentioned this in a previous episode, my constitutional law professor, when talking about this exact subject of how women were treated in the early days of colonial antebellum periods, was that the idea was the husband and wife are one, and that one is the husband. And thankfully, it's not like that anymore. And we've definitely progressed, but that's sort of, a theme from back in the day. We were seen mostly as wives and mothers, so that was tough. But we could inherit and money and property, but only single women could, and widows of course, could actually own property and sign contracts. Now, if you were a married woman, it was your husband who owned the property. If you inherited it or owned it when you got married, then that automatically went to the husband. So definitely have come a long way from that. And some of our senior tips for women involve those important issues of things like who's on the deed to your house. And then later on, in 1868, we had the enactment of the Married Women's Property Act, and that had been a law that was being issued in most of the other states of the United States, and we did that as well. We had a previous level of law episode on the Married Women's Property Act of South Carolina, so definitely go back and have a look at that.
Lost everybody.
I hope we can get him back.
Kenneth? Producer Kenneth? Is that you? Hello? I think that was Kenneth in the background, making sure that all the bells and whistles are working. The final thing here in this period of time was that the skills that women were to focus on were those that made them good wives and mothers. So those of us who are, or you who are independent women, will probably have a little chuckle at that. And so we can talk a little bit about divorce and custody and how that was in South Carolina. So for a long time, there was no provision for divorce except for one short period in the 1860s. And so as a result, women might try to go out of state to get a divorce, but then that was affecting the rights of the man who was the father, and so it was a risk because you might lose custody of your children if you tried to do that out of state divorce. So it's interesting how things develop for women. But eventually the child custody and child support and all that have come to be what is in the best interest of the child, and are the parents able to support the child. And just another note here, you hear about the tender years doctrine, which basically is if it's a very young child, toddler, baby, that sort of thing, then it would be the mother would be presumed to be the one who should have custody. Now that was abolished in 2008, but even in my early years of practicing law and family court, there were definitely women who still thought that their husband wouldn't be able to handle it and would, wouldn't be able to change a diaper and things like that. And so they thought that that should affect the custody or the visitation. But judges typically didn't buy that, and they certainly don't now. So one side note that we thought was interesting, and this was just in 2005, but a law was proposed then on to make it against a lot of battered women. That didn't pass, but that year the anti-cockfighting law did pass. So that was definitely an interesting contrast for us, and that was not all that long ago. Okay, education, and certainly education for women has come a long way, but in the late 20th century here in South Carolina, we were still, less likely than in the whole United States to have completed a 4-year college degree or even finished high school, even though we were entitled to the same educational opportunities and the same scholarships and so forth. Here's a little history of employment of women. It was very limited, certainly, for women prior to the 20th century, but things, did improve. But I think it's interesting that in the earlier days that women were thought to need to act as a hostess for their husband, run the household, and unfortunately in the South that would often include supervising slaves. But by 1900, about 38% of all South Carolina women were employed outside of the home. 14% of white women worked, while about 2/3 of African American women worked. But these were mostly for the African American women was out in the field still. So things did not progress as fast as we would like. And then it's interesting the different kinds of jobs that might be available or would be sort of designated for women, such as mill workers if they were white, or maids if they were black. But by 2000, about 3/5 of all South Carolina women were employed outside of the home, and we were 16th in the nation in the percentage of women who held professional and managerial positions. So not totally at the bottom of the barrel like we are on so many things. So we are, some of these barriers, many of them have been removed, but there's still, of course, work to be done. Here's some statistics that we found just for 2000 in South Carolina versus the nation. We have a smaller percentage of white women working and had to overcome the racial discrimination. A larger percentage of African American women at 30.4, and non-white women 4%, and then Hispanic women was 1.9%. So those were some interesting statistics on that. Voting, the 19th Amendment was passed into law in 1969. Our General Assembly did not ratify it, but did pass a law giving women the right to vote once that 19th Amendment became law, and some women were registered to vote. Interesting that there was a law passed excluding women from jury duty in South Carolina, and that was until 1967. And by 2000, 56% of the state's registered voters were female. We were rocking by then, so that was good. Okay, so as of the year 2000, still not parity despite all of the gains that have been made. The poverty rate for South Carolina women was almost 13% in 1999, 26% for African American women. And then more than 30% of households who were headed by women where there was no husband present fell below the poverty level in 2000. And women earn less than 71% of what men earned in 1999, ranking 37th in the nation in terms of median annual earnings. So let's, on a happier note, we're lawyers. We're going to talk about the gains of women when it comes to the legal system in South Carolina. And these are just a few. And in the future, we will do even more on this. But in 1918, women were able to practice law. And, we note here Miss James M. Perry. She was the first woman lawyer in 1918 here in South Carolina. Judy Bridges became our first female judge in 1983 in the family court. In 1988, Jean Toll became the first woman to serve on our South Carolina Supreme Court, and then she later became Chief Justice in 2000. Carol Connor, first woman to serve on the state circuit court, and became the first female judge to the South Carolina Court of Appeals in '93. And then in 2000, Kay Hearn, the first female Chief Justice for our Court of Appeals. So women in the practice of law and the legal system continue to make great strides here in South Carolina. So I'm going to turn it over to Jamie Bell to talk about common law marriage in South Carolina, continuing our theme of the Godfather of Soul, James Brown. Take it away, Jamie.
Thanks, Susie. So again, many of you probably wonder what James Brown has to do with common law marriage, and there's a very interesting case regarding his estate that deals with some of these issues, and you can actually look on the Supreme Court's page and read those opinions. But just to give you a little bit of a summary, he was married in he signed a prenuptial agreement or a prenup in 2006 with Tommy Ray Heine, and she agreed to waive any claim of common law marriage to James Brown, both now and in the future, is what the agreement said. Well, it turned out that when she married him, she was still married to someone else, and the husband that she was still married to was married to 3 other people. Miss Heine annulled the marriage with her previous husband in 2004, but in June of 2020, the Supreme Court said that the marriage to Brown, while she was still married to the previous husband, was bigamy. So that annulment did not make her marriage to James Brown valid. So she could have married James Brown again, but by this time, the two weren't getting along, and that just wasn't going to happen. So let's look at the difference between a ceremonial marriage and a common law marriage. And you can just see some of the things compared here on the slides. And when most of us think about getting married, we think about a ceremony with an officiant and a marriage license, and you have a wedding date. And of course, you understand that if you're married in a ceremony and you want to dissolve that marriage, you have to get a divorce. Well, on the contrary, common law marriage doesn't have a marriage license. It really depends on the facts of the relationship as determined by the court. And that's going to depend on what both of those parties say. There's usually no kind of set anniversary date or wedding date, and it's determined by the probate court or the family court as to whether or not a common law marriage actually existed. And if you are common law married and you want to dissolve that relationship, then you do have to get a divorce. So let's look at a brief history of common law marriage. And I thought this was very, very interesting. So common law marriage was allowed in Rome until 1563 and in England until 1753. But in most of the United States, it was changed somewhere between the 1800s and 1950. Well, in true South Carolina form, we were late to the party, and we changed common law marriage or abolished common law marriage in 2019. So what that means is that you can't start a common law marriage after July 24th, 2019 in South Carolina. And again, if you want to read that case, it's Stone versus Thompson, and that's available on the South Carolina Court's website as well, Supreme Court's website. So why would common law marriage exist? There were a lot of reasons it existed. One thing was travel and the lack of officials. So usually only a clergy person or a judge could marry someone, and they rode a circuit. but they didn't, it's not like today where you can just drive up the road to Spartanburg. They would only be in that area at a certain time. So there was a problem with waiting on the official to get there. And it was also a cost involved. So you had to pay that person, and there might be some other costs and considerations going on. Freedom from government oversight. A lot of people did not want the government involved in their relationships. So common law marriage. And legitimizing children. So if children are born to married parents, they're considered legitimate and they could inherit from that father. And this plays off a little bit what Susie was talking about as far as property rights. If the parties weren't married, then there's a difficulty in the inheritance. And the unequal results of the lesser earning partner not being recognized. So, I mean, just still, if you think about what Susie said previously about the women's property rights prior, and in the 1800s, so you would think about why this is another reason why you would want to do common law marriage. So how can it affect you? Inheritance, immigration, alimony. A lot of you probably already thought about some of these. Property and asset division, name change, tax benefits, this liability for debts, life insurance, health insurance, custody, healthcare decisions. There are all kinds of ways that marriage and common law marriage affect our relationships and how we interact with the government and with society in general. So let's look at the difference between common law married and being romantic partners, because there are a lot of effects that you might not think about. Most of these, that I think about, revolve around children. And so if there is a domestic violence call and law enforcement come to your house, then there might be an issue as to whether or not who should have custody of the child once the parties separate. So if you're married in South Carolina, you have equal rights to the children that are born during that marriage. We also have an unmarried mother statute. So if you're not married, the statute considers an unmarried mother to have legal custody of that child unless there's a court order to the contrary. And so that means that if your partner, your husband, or your boyfriend wants to take the child, if you're common law married, then that's a issue, because you have equal rights to the child. If you're not common law married, then the law presumes that you have custody. We also see this a lot in estates when there's no will. People want to establish common law marriage for inheritance purposes. And this is particularly an issue when the other partner had children from another relationship, because those children will take everything if the decedent was not married. And another place we see it is in the Adult Healthcare Consent Act. So if you don't have an estate planning document like a healthcare power of attorney, then our Adult Healthcare Consent Act gives priority to a spouse and then to a bunch of other people before any kind of romantic partner. There's also a spousal privilege in a civil case, which means that a spouse can't be compelled to disclose a confidential communication to the court. And in a criminal case, the spouse can't be compelled to disclose any communication. So that spousal privilege does not exist if you're not married. And then the doctrine of necessities. where a spouse can be liable for collection of the spouse's necessary debt. And that's usually a medical debt of some sort, usually like a last or final expense. So if the people aren't married, that person can't be held responsible for that. So just because someone says you're common law married doesn't make it so. And I think for me, the thing I hear the most is I hear people say, well, we've lived together for 7 years, so in South Carolina, we're common law married. Well, maybe. That doesn't make you married. Living together does not make you common law married in South Carolina. So we look at all of these different things when we're trying to determine if people really are common law married. And we're looking at whether or not these things were displayed by both parties, not just one party. So the first, and I think the most important thing, is did any party have an impediment to marriage? So mainly what we're talking about here was, did either party, were they married to someone else? Because if either party was married to someone else at the time that this common law marriage was allegedly established, then it can't be a common law marriage. But we also look at cohabitation. We look at tax returns and records. How did you file your taxes? Did you file together? Did you file like married filing jointly or married filing separately? Did you wear rings? Did you have any kind of a ceremony? Did you use the other party's last name? Did you hold yourself out to Mr. and Mrs.? So things that we're looking at here are, did you introduce yourself as Mr. and Mrs. Doe? Or did your mail come to Mr. and Mrs. Doe? What about a death certificate? Does your partner's death certificate list that person as being married? Or does it list them as being single or widowed? And if you're the informant on that death certificate, are you listed as the spouse, friend, partner, etc.? Because that's evidence of your relationship. We also look at obituaries and greeting cards. Did you exchange anniversary cards to my loving wife on our anniversary? We look at church bulletins and directories, insurance records. A lot of times when you name someone as the beneficiary in an insurance policy, it asks you what your relationship to them is. Do you put friend or partner or spouse? Any citizenship documentation and any advanced planning documents. So a lot of times when we do wills, we'll say, we do something called declarations that says I'm married to James Doe, or I leave my property to my husband, James Doe, or if you're doing a power of attorney, you categorize that person as their relationship to you. So these aren't an inclusive list, but it is a pretty good list of where we would look at determining common law marriage. So at this time, I'll just stop and take any questions that you might have about common law marriage. Susie, do we have any questions? I'm sorry, Susie, I can't hear you.
I don't see any questions as of yet. So we'll check again when you're finished with the tips in case anyone has a question about today's topics. Okay.
Thank you.
You're welcome.
So let's go forward with getting our legal house in order. So we want to get up and get our legal house in order. So the first thing is independence. You want to make sure that you are becoming independent, or you maintain your independence as far as your finances and your property goes. You want to embrace the fact that you have those rights that we talked about that we used to not have, ladies, and your own power. So what does that mean? Know what you own. Know what you own, know what you owe, and know what your income is. You would be surprised how many people do not know those things. But you want to make sure that you know those things. If you have adult children, don't endanger your own finances by going into debt for them. I've always heard the saying, you can take out loans for college, but you can't take out loans to retire. Be careful of family members that are new to sales or finance. Hey, I got this great investment. Do you want to get on the ground floor of this new idea? Just be careful about that. And if you've got a family member that's serving as a caregiver, then get a personal caregiver agreement. What you expect them to do and what they are going to get in return. And because a lot of times when this comes up is during the probate process, when a certain person has been the caregiver and they think that that entitles them to usually the property or the house. And also be transparent about your finances. If you don't own a lot, just say, look, this house is the only thing I own. Just be transparent with your children. If you don't have adult children, then look for a trusted friend, neighbor, church member, someone that you can trust with your finances, your property, your healthcare decisions, and make sure that that person is willing to do those things, make those decisions, or help you with those things. But also make sure that they have their own income, their own assets, and their own retirement, and that they don't need yours. And also be careful of any kind of targeting of seniors on the internet or on TV. You know, those commercials about your Medicare. We can get you a better Medicare deal. Just be careful about those things. Mama always said if it's too good to be true, it probably is. And my life experience has just told me that that's usually the case. So let's make sure that your financial house is in order. You want to make sure that you get a will if you've lost a person that was a beneficiary, or that was maybe the personal representative of your will, then maybe you need to update your will. Don't wait to do that. You might want to consider a power of attorney or a healthcare power of attorney. A power of attorney will appoint someone to handle your finances and your property. If you're not able to do that, a healthcare power of attorney appoints someone to make healthcare decisions if you're not able to make decisions for yourself. And here at South Carolina Legal Services, we do these documents regularly. So if you're interested in those, please reach out to your local office. You want to also pay attention to your healthcare coverage and your Medicare. Each year, you know, you have to select your plan and that kind of thing. You want to make sure that your doctor is still in your network. What's your deductible? Has that changed? Have your co-pays changed? Nobody likes a surprise when they check out at the doctor. So you want to be on top of that stuff. And I think it goes without saying to save so you don't have to borrow for an unexpected expense. I mean, we all have those unexpected expenses, whether it's a car accident or a leaky roof or you know, just whatever. It could be an unexpected illness. So save so you don't have to borrow, and save for retirement. And that's especially true if you're self-employed or you work in some kind of family business where there's maybe not a 401k option. The days of Social Security begin the sole retirement plan they're over. So you need to have some other option for yourself. And make sure that you review all of your financial documents, insurance policies and your beneficiary designations. That's true on your bank accounts. It's much easier to transfer things that way. Make sure that you know where the deeds to your property are and who's on the property, because a lot of times we might think that I might think that I'm the only person on my property, but it's been so long ago since we purchased the house that I might have forgotten that my husband is on it as well. So, you know, you want to make sure that you look at those and know who's on the deed. Also, agreements for any partnerships or LLCs or businesses, and your bank accounts. Again, I think we've already talked about that. And a lot of times people just want to add someone to their bank account. I mean, I'd be very careful about doing that, because anybody that's on that banking account can withdraw or deposit funds as well. So you want to be careful about who you're giving that access to. So when you're divorced or widowed, you know, that's another one of those life-changing events where you need to you have to take control of your life and be responsible for you. Sometimes that's really scary, but don't be fearful and don't allow yourself to be dependent. Pursue any Social Security survivors benefits. If you're widowed, if you've been married to your divorced spouse for more than 10 years, you might still be entitled to some benefits there. Pursue that with Social Security. And a lot of times when you become divorced or widowed, we do want to get involved in a new relationship, but we really need to be careful about that and objective about that, and maybe even seek some kind of professional advice. So be careful about new big financial moments. Buying or selling property, transferring property, retirement, those kinds of big financial moments. Don't do those on a whim. Don't be in a hurry when it comes to financial matters. If it's a limited time offer and you got to act now kind of situation, that's a flag that something might not be right. Consider changing your beneficiaries on wills and insurance policies and stuff carefully. Don't do these on a whim. Make sure that you're doing them for the right reasons as well. And if you do get involved in a new relationship, you need to be careful about commingling your funds. That can be really tricky, especially if one party is receiving SSI, because SSI is needs-based and it has fixed asset limits. And so if you're commingling your funds, that person can easily reach that limit and come up with an overpayment. Also consider a trust for your own children, especially in this day and age. We have a bunch of families that are blended families where both parties have children from other relationships. So if you're wanting to protect your children's interests, you may want to consider a trust. And when you're considering new relationships, don't look for a replacement or someone that's going to take care of you. Make sure that relationship is authentic and genuine, and make sure, again, that they have their own assets, their own income, and their own retirement savings, and they don't need yours.
Yeah, and Jamie, I want to just interject something, because I do see this a lot. You mentioned considering a trust for your own children if you are getting remarried and, you know, have children from a previous marriage. So often I see people who have done a trust document. There's a lot of people out there who will do one of those for you. Be careful who you choose. But you also have to put something into the trust just because you create the trust doesn't mean that there is something in there, whether it's your house or money or, you know, whatever assets you have. If you want those to go to those children, you have to actually put them in the trust. So that's just a little tip I wanted to add there. So I've seen so many people who say, oh, well, everything's in a trust for my children, but they never actually put it into the trust. So that could be done. Okay. Well, we do have some questions, Jamie, if you don't mind. One question is, an estate planning attorney who's a man recommended not naming your common law spouse as your husband in the will, also in a durable power of attorney or healthcare power of attorney, saying that the probate court would not recognize that.
You know, I haven't come across that, but the probate court is going to make that determination at when the will is probated. And I don't think that if you're naming them in a will, I don't think it's going to probably matter as much. It's usually in the intestacy when people don't have a will that we see the problem.
Right, I agree with you. And you know, the James Brown case, that was a probate of his estate, right?
Yeah.
Where they were making that determination. So, and I guess that there is a drawback to if you do consider yourself to be common law married, and this had started before July of 2019, then you know, certainly you want to consider whether or not that's going to be a detriment to a finding of common law marriage. If you're relying on that you and this person are married by common law, then as you mentioned earlier, there's a whole list of factors, one of which is, did you name them as your spouse in the will? And if you don't do that, that could have an effect on any kind of decisions by a probate court as to whether or not you were in fact common law married. Because like you said, it does have to pretty much be a court order that makes a finding of common law marriage. I think that's actually our only question. Let me just double check here. Oh, no, there's more. Okay. My daughter has 3 children by her spouse. They've lived together for several years and have worn wedding rings and refer to each other as husband and wife. They moved from Georgia to South Carolina in June of 2021 and applied for a marriage license. The spouse purchased a home, but my daughter's name is not on it. The spouse says that said one day he didn't think it was going to work and didn't want to be married, told her she needed to move out, and then proceeded to give her a 30-day eviction notice. Wow. You want to take that one, Jamie?
So,
that's kind of a specific question, and we can really only give general information. But
yeah, we really can't answer case-specific questions in this forum, but I would just go back to those factors, and you have to look at all of those factors and determine whether or not there's a common law marriage. So if your daughter is interested in maybe establishing a common law marriage, then she needs to contact our telephone intake service.
Yeah, it would be a tough case, it seems like, to have. Now, every jurisdiction is different. We only practice law in South Carolina, so I don't know the jurisdictional issue of coming from Georgia to South Carolina. We can't really comment on that in this particular forum, but it's important, as Jamie said, to get a lawyer to go through all of those issues, because you know, if you've got all of those, what we call indicia of a common law marriage, meaning factors that indicate that you were common law married, intended to be married, and so forth. I'd be interested to know if there actually was a marriage license, but that could be a factor against it it seems like, because if you're common law married, then you would feel like you didn't need a marriage license. But a move might affect that. So all kinds of factors can be looked at and considered by a court, and that's definitely what would have to happen in a situation like that. Okay, here's one more question. Does putting your assets in a trust protect your property from estate recovery by Medicaid?
Well, I'll just tell you that we don't do a lot of trust here, just because most of our clients just don't have the assets to do that. And there are some waivers for Medicaid, estate recovery, but I think that that's a whole different webinar.
Yeah, and we'll definitely, if we haven't done one already, that's one we can definitely do. But I would say that, am I right, Jamie, that Medicaid is really, for the most part, used when you really don't have a lot of assets,
Yes,
right?
that's correct.
Yeah.
Usually the asset that Medicaid is looking at taking is the real estate, the property.
But they will file a claim on your estate, that is for sure. I think that's all the questions we have. I will check just again in a minute, but for now, I do want to thank Jamie for joining me today. It's been a really interesting topic, and I love having the James Brown thing. Gives you a lot of food for thought for sure. But you're seeing on your screen now how to get in touch with South Carolina Legal Services. You can call us Monday through Thursday, 9 to 6. We have great intake specialists who will ask you a bunch of questions that are designed to determine if your case is the kind that we do handle and whether or not you're eligible for our free services. Our services are free here at South Carolina Legal Services. We're a nonprofit law firm. But you can also apply online 24/7, which is a great feature that we have now and have had for a while, thanks to Tom Trent and our intake office and his great folks. You could do it either way. And also, we have a lot of resources on our website and on our social media. You know, obviously on our YouTube channel, you can find the recording of this and other presentations that we have done that are similar. A lot of information there, and on our Law Help page, different resources. We have brochures on any number of topics, and you can find those and download them for free on sclegal.org. And I would ask you that if you found today's presentation of interest or valuable to you or to someone you may know, we definitely ask that you go to our YouTube page. Kenneth usually has it uploaded there pretty quickly, and you can look at it again if you think you might have missed something. And also you can share it with others right straight from that YouTube page. And while you're there, please give us a like and subscribe so that you'll always know when we've uploaded any kind of a video to our YouTube channel. Not just these Level Up Law episodes, but anything else that we do that gets uploaded there. We definitely ask that you do that. So let me just quickly give a mention of what's coming up in April. Since this concludes March for Level Up Law, we'll be starting next Tuesday at noon, and it's Second Chances Month. And just want to give you the lineup for April. First, on April, April 12th, we have how to modify child support obligations in South Carolina. I'm sorry, I should have started with April 5th. Getting back on the road, tips to restoring your driver's license in South Carolina. Then on the 12th, modifying child support. On April 19th, do you have proper identification? That's really important these days. You've got to have that proper ID. There's different ways to get it and also to modify it. And then finally, on April 26th, removing barriers by way of expungements and pardons. That's a really important topic, and we have shared information on that before. but for Second Chances Month, we're ramping it up and giving you a lot of good information on all these 4 topics. So definitely be sure to join us. You can go to our website, I'm sure right now, and register for those now. You won't even have to wait for an email or other kind of notification. You can go ahead and sign up for all 4 of those right now. And we definitely encourage you to do that. I am going to look here because we do have, I think, Jamie, a few more questions. So let's look at that before we go. Well, maybe not. Maybe we did get all of those. Let's see. Yep, I think we did get all of them. So we're done for today. Let me just one more time thank Jamie Bell from our Rock Hill office. She's a terrific managing attorney up there, doing great things for legal services and the people that we serve in that area. Thanks so much, Jamie. And thank you to our audience for tuning in. We really appreciate such a great audience today. So many people have signed up and registered, and we really appreciate that. Be sure and share the information out, though, because it's really important to us that as many people as possible get the information, not just about the particular topic, but about how to get in touch with us and apply for our free legal services. So thanks, everybody. We appreciate you tuning in. That concludes today's webinar.